to go ahead and turn this over. Our presenters today are Joan Bibelhausen and Chase Andersen. They are both from Lawyers Concerned for Lawyers, and I will let them introduce themselves and dive in.
Thank you, Sarah, and thank you to the State Law Library for bringing us in to do this program. We appreciate the opportunity, and we appreciate all of you for attending. My name is Joan Bibelhausen, and I'm the director at Lawyers Concerned for Lawyers, and I'm going to share my screen while Chase Andersen, my colleague, does a short introduction of himself.
Hello, my name is Chase Andersen. I'm a case manager at LCL. I've been with LCL for 7 years, and prior to that, I practiced divorce and family law in the metro area. So as we're going through today's program, I will likely make some reference to my family law experience. Also, I have included LCL's contact information in the chat, and I will be keeping an eye on the chat for questions. So please let us know if you have questions. And with that being said, I'll turn it back to Joan.
All right, thanks, Chase. And I would echo that if you have things you'd like to expand upon or learn more about, we're not clear, that sort of thing, please let us know. And so what we're going to talk about today is a little bit about who we are as professionals and how some of the challenges we have, what that means in terms of ethics. And we're also going to talk about what kinds of ethics issues might arise with clients if they are dealing with some sort of impairment or difficulty. And then we're going to talk about the kind of help is available, including some resilience resources. So this is, excuse me, this really is a survey course. We're going to be giving you a lot of information in an hour. And these are the kinds of things where I'd like to learn more about that. Well, we may have another program, or you can always contact us and we can go into it further, because we're going to be noting a number of really important things, but not getting down deep into them, because we're trying to identify all the ways in which these kinds of issues can give rise to ethical problems. And I think there are some we aren't raising. So Chase, why don't you talk a little bit about our organization and how we help people?
Yeah, just a quick in a nutshell, Lawyers Concerned for Lawyers is Minnesota's lawyer assistance program. Every state has a similar lawyer assistance program. We are the longest consecutively run lab in the country. We help lawyers, law students, judges, their immediate family members, and also support staff too. We provide help and support and services on anything that may cause stress or distress in your life. And that can be stress, anxiety, other mental health issues, cognitive issues, work-life balance issues, well-being issues, substance use, addiction. So the big ticket things that we hear about, and even the small little stressors. And we are totally free and we are totally confidential. We don't report any information to any licensing entities, employers, family members. And on average, we help about 400 individuals per year. So again, we are kind of the safety net for the legal profession. And whether you call us today or tomorrow or a year, we're not going anywhere. So just keep this in mind if you're ever coming across any of those challenges that we face as attorneys.
Thanks, Chase. And another thing I would note, excuse me, is that a number of you might have employers who provide an employee assistance program. And so you can add those benefits together and receive additional counseling. And we can always talk through what that means. All right, so let's get started with kind of putting things in perspective. Looking at the idea that if you think about 3 years ago, there are things on our radar now that were not to the degree that they are now, or were not at all in the case of COVID. And so when we think about what our profession is dealing with, we are experiencing these issues. And by the way, any critical issue in our society, our profession is on the front lines, one way or another. It might be policy, it might be litigation, it might be something else, but we're on the front lines. And then the clients and the parties, they are also dealing with these additional stressors, and that is coming into our offices, or it is something that we're exposed to. And so being aware that there is just more that is affecting us. And in our profession, we hear about things like, if you're in private practice, we hear about things like billable hours, and we hear about things like difficult opposing counsel and all of that. But there are some things that we like to take a little bit deeper to talk about the way we think that can be contributors to our stress. And so I'm going to go through these and give you a little bit of information about each of them. First of all, if you remember your first year of law school, you were told, you can't miss a statute of limitations because that could be malpractice. In other words, don't make any mistakes. So right away, we're thinking, oh my God, I have to be perfect. And we have our shoulders bunched up and we're thinking about that as I can't miss anything. I can't miss anything. And so that perfectionism can make us more prone to illnesses like depression. And, we are going to make mistakes in our lives, in our careers, and sometimes it has no impact. You miss a stop sign, nothing happens, you breathe a sigh of relief. But sometimes something happens, and then there are consequences. So you deal with them and you move on, and we learn from those mistakes. So the perfectionism, if we make mistakes, we will move on. If we are striving for perfectionism all the time, we may make more mistakes because we are so stressed out and not doing our best front of mind thinking. We tend toward looking for the worst that could happen. And in fact, in a study that was done of graduate students, those who were in law school tended more toward pessimism than every other graduate program. But the pessimists in law school got better grades because law school exams are about what could go wrong, right? So the better you could see those things, the better we do as lawyers. But we don't have to always be that way. And yet that way of looking at things and looking for the dark side can mean that we are not willing to look at ways that things can be better. And so that's the sort of perspective that an organization like LCL can help with. We also are subject to isolation and uncertainty. We do a lot of our work alone, and we don't always have feedback to say, no, really, you're doing okay. And so that can give rise to imposter syndrome and other feelings of, am I good enough? And so we need to find ways to connect and understand that we are doing what other people are doing. And if you are struggling, that's why we're here. And then we're exposed to other people's trauma. And this is a whole seminar in itself. So here I will just acknowledge it, that our clients and parties have had some sort of traumatic event in their lives. It may not be something that would be traumatic to you, but it is to them. Or you may have come to law school because of the trauma you experienced at some point, and you want to make a difference with that. And so how do we handle trauma in our profession is a really important topic. And we talk about that in other programs. And if you would like more information, obviously we're here to tell you about that. So we are having a lot of stress in our profession because we are dealing with people who are undergoing stress. And that is a given. We're going to experience it. And it's difficult to manage it sometimes. And we hope, I can just handle it. It's all okay. I don't really need to do anything. But the fact is, if we're not attending to it, we're not going to do as good a job. We're going to have more health problems, and we're going to engage in unhealthy coping mechanisms like drinking too much, which is a risk for us. And I'll talk about that in a minute. So this is an ethics program, and I want to start with the rule on diligence, which is very basic, that a lawyer shall act with diligence and promptness in representing a client. We all know that rule, but often we aren't as aware of the comments. And the comment to the rule on diligence, one of them says that the workload must be controlled so that each matter can be handled competently. So I would suggest in our first flash of ethics in this program that the rules give us permission to do what we need to do to support doing our best work. And that includes self-care so that we can do that. A little bit of data. In our profession, this is from the ABA 2021 profile of the profession, 20.6% of us drink more than the doctors think we should. And that's compared with 6.5% of the population. Well, okay, probably more than 6.5% of the population that end up in lawyers' offices might have a problem with alcohol. Newer lawyers, it's closer to a third. Mental health issues, over 1 in 4 of us have met criteria for depression during our careers. and almost 20% a difficult level of anxiety. And a very important thing to know is that just over 10% of us, when asked the question, have you considered suicide, said yes. And I've got another graph here just because I like to show you that we have one where we show the judges have a drinking problem or are drinking more than the doctors think they should at 9.5%. So it's not as much as the lawyers, but it's more than the population as a whole. So I'll just leave that there for you to think about. And when we talk about alcohol problems, what we're looking at is a primary disease, and it affects every part of our lives. So it can be genetic, but it might not be. It can be something that is triggered by an environment we grow up in or circumstances we experience. And if someone does develop an alcohol use disorder, so that's diagnosed, it's not just somebody who might drink more than the doctors think they should, then it can be progressive and fatal. And that's where recovery is going to be an appropriate option. But what happens, some things to recognize, and you may recognize this in clients or parties, is that despite one's best intentions, at any given time, you may drink more than you planned. And this may remind you of someone you're concerned about too. You might think about it more than you think about other things. You change things in your life that are for your own good in order to have access to alcohol. And you convince yourself and you do your best to convince others that there's no problem. In addition to alcohol, lawyers and parties and clients have problems with other drugs, as well as compulsive behaviors. And in fact, we have a whole program on problem gambling. These are issues that give rise to legal problems. Sexual compulsivity is going to be present in family law cases. It's going to be present in employment law cases because somebody is using their computer at work to look at inappropriate images. There's a discipline case around somebody who was a compulsive shoplifter. These are all issues that LCL has helped people with. And in addition, you're going to see perhaps other issues with clients. Chase, did you want to make any comments about that? I know that sometimes you see things in practice that you want to call attention to.
No, that's fine.
Okay, all right. And then when we look at depression, what we're seeing is that if you have a loss of normally pleasurable activities for a period of more than 2 weeks, where you feel an emptiness, where you're having trouble finding interest in things that you used to be, if you're having difficulty concentrating, remembering, or deciding, that's where we notice it. And by the way, you may have a client or a party where you think of this, and Chase is going to talk about that later. You can't just wish it away. And if you're concerned about somebody else, there may be changes in behavior. Depression is also the #1 predictor for suicide. And we're not going to really address suicide prevention today, but we will be doing a program in January for the State Law Library that will be an entire hour on suicide prevention. So look for that. And if you do have concerns about someone who might be suicidal, please contact LCL. In addition to depression, we experience other mental health issues as well. And this is a list of some of the things that LCL has helped with. And by the way, depression is out there. There's a website called Lawyers with Depression. There's Lawyers Depression Project. There's things like that. Within that, they're also talking about anxiety. And in what comes to LCL, especially over the last 3 years, anxiety has been, there's been a greater percentage. And the rest of these issues are all things where LCL helps people. In addition, with clients and parties, you may have things like personality disorder, schizophrenia, things like that.
And I do want to comment, Joan, that
yes,
with the substance use or the mental health issues, if maybe you're dealing with something that isn't on that list, we still want you to know that you can contact us and we can put you in support in contact with somebody that can support you in that area. So, and maybe it's a client, and I'll get into that, but this is not an all-inclusive list, and I just wanted to point that out.
right, okay. We saw some data around newer lawyers before, and I just want to note that the numbers are higher for substance use and depression. Sometimes you can, we've been in meetings where we've said, okay, why do you think that is? And the responses we get range from, well, there's more stress, you're earlier in your career, that's stressful. But we've also had responses like, I believe that my generation is more willing to ask for help. And as a result, I'm more willing to be honest and say, yes, I have dealt with this. So that's kind of a good side, a good way to look at it. But if you are you thinking about the newer lawyers in your organization and you have this data that the rates are higher for newer lawyers, then as a person who is a supervisor or in a supervisory relationship, you may have a duty to pay enough attention to make sure that that person isn't making mistakes. And that's Rule 5.1, where you can be held accountable. It also, if you are engaged in having well-being initiatives and you're trying to have some benchmarks, being aware of that data for new lawyers is important. So we're going to move on and talk about kind of the ethics piece a little bit more now. And when we look at what is happening in Minnesota, when I was in law school, the person who was the director thought that half the cases that came in the door involved alcohol. And I asked one of the lawyers not too long ago, and anecdotally, they said it's probably still a third. So our point there is that it may not be you, but it will affect you because it may be the lawyer on the other side, down the hall, the judicial officer. And so if somebody is on probation, and we'll talk about that kind of stuff a little bit later, they may be, and they have mitigation where they brought up the fact that they had a diagnosed illness. They may be required to demonstrate that they are doing things to maintain recovery if that's part of the probationary agreement. With mental health, the half the cases where the file is open involve neglect and non-communication in some way. Well, the lawyer who is not communicating with a client or a party to the extent that a file is actually opened is not a healthy lawyer. And non-cooperation where you haven't responded to the board, that's not a healthy lawyer either. So I think that mental health issues are pretty present here. I just want to show you this diagram that shows some of the issues. This is the tip of the iceberg. And then underneath, you see all of these challenges that are out there. And one of the things that I want to call attention to is the term alcohol/drug abuse. The idea being that if we use a term like abuse, and this is the old word, okay, but I have it here so I remember to talk to you about it. Abuse is pejorative, it's shaming. And so if you are in fact having a conversation with someone, working with someone, an alcohol issue is an element. Think of it as it is an illness that somebody has. It is alcohol use disorder. And your relationship is different because you are not characterizing them as a quote unquote bad person. And when we have these mental health issues, it's been referred to as an ethical sinkhole because we get anxious, we get stressed out, and we act very rashly in our own self-interest, which means that we think it's reasonable not to respond to the board. They don't know what they're doing, I'm doing fine, and that really isn't in your self-interest. And so these things that affect us might lead us to avoiding what we need to. And the kinds of rules that can be implicated there have to do with our very competence, as well as whether we're being diligent and communicating. And so some other ways in which we can see these things arise is, first of all, the criminal justice system treats mental health and substance use and behaviors very differently than they did years ago. So it is characterized as something where there's an illness present, not just a bad actor. And that is something that we can all be involved in, whether it's problem solving courses or other initiatives. These are some of the things that affect lawyers that I'm going to go through to draw attention to the kinds of things that might impact us. So first of all, if you are challenged, you're stressed, you're grieving, you're going through something that is keeping you from being able to do your best work, then you are expected to decline representing someone or terminating the representation because you're not able to have that work. And we have had lawyers call us and say, I need to refer this client. I need a continuance. I need to do something because I cannot adequately represent this client right now. And we will help you figure out the options and move forward. I mentioned the rule on diligence earlier, and it's interesting that this comment only applies to solos, but it is something that I think everybody and every organization should think about. That what is your plan if you are suddenly unavailable? Who's going to take care of your clients? Where are your passwords saved? These are the kinds of things that we get calls about where people don't know what to do and they don't know where to find the information. And it never benefits the client or the party. If the lawyers board has to get involved, what happens is that the cases, everything's returned and you have to start over. So what's a plan that can be held, that can happen in there? We have rule 8.3, which is, depending on the bar review course you took, is either called the squeal rule or the rat on your friends rule. And this is the one that requires you to report another lawyer, but read the language carefully. If you are aware of a violation of the rules, okay, so it's not somebody did something, it's a violation of the rules, and as a result, you have a significant question about honesty, trustworthiness, or fitness, then you're supposed to call the lawyers board. And this is something where you can call and get an advisory opinion and say, am I required to report? Rule 8.3c has an exception for people like Chase, like me, our volunteers, who might learn of this potential misconduct because we're supporting somebody. And so there is no requirement to report in those circumstances. It doesn't mean we can't. It means we don't have to. What these two rules mean together is, first of all, LCL is never the appropriate professional authority. It's not enough to call LCL. However, you can call the board and LCL, and it doesn't say when. So you could get LCL involved in a situation where someone is struggling and needs help. And by the way, they may have committed a violation that you need to report. And then once that person has some support, that report, if it has to be made, can be made. I want to talk about mitigation very briefly, which is something that I think it's important to know, which is that misconduct can be mitigated in the case of substance use issues if 4 factors are present. And the attorney has to claim mitigation and this is in the case of alcohol, the Johnson case. They're affected by it, that it caused the misconduct, that they're in recovery, and the misconduct is arrested and not likely to recur. And then a year later, the Werrick case applied it to mental health issues. And the sites are there if you'd like to look at that for more information. Today, if we look at mitigation, what we have found in these cases, and they're a little older now, but they were very consistent, is that causal connection is extremely difficult to prove. And what we see is that sometimes lawyers will say, well, I don't want to raise this because it's one thing to miss a deadline and people say, oh boy, I could have done that, but it's another thing to say, I have a diagnosed mental health condition and have everybody know my private medical information, which is why the Clark case, which has a comment to this effect, the medical records were sealed. And so simply they said, we have seen the records. We are granting this. We don't have to tell you anything more. The public's right to know does not apply to your medical records. And so what it means ultimately is you may say, I've got an issue, I need help. And that gets you, that helps you be dealing with it while you're on the road to recovery. It doesn't mean that you always have to have a discipline like a suspension or disbarment. It can mean that you might be placed on disability and active status while you deal with something. And you may then, you got to figure out what to do when you come back. And when mitigation is present, it's typically in the context of probation. So now I'm going to move this over to Chase, who's going to talk about how does all this apply to clients and kind of provide some of his own experiences from practice. Chase.
Yeah, thanks, Joan. And so Joan focused about the stressors and how that affects us as attorneys. I want to spend a little bit of time talking about how those stressors affect clients, stressors along with impairment. And keep in mind that while it might be the clients that are dealing with these challenges, we as attorneys are often dealing with them secondarily as well. So next, please. So I want to focus a little bit on diminished capacity, and when an attorney is communicating with their client, you have to reasonably maintain a normal client relationship, even though you think there might be some type of an impairment involved. And so the key language here is reasonably possible. So we'll get into what that diminished capacity could look like, but if at all possible, you're supposed to maintain a normal client relationship with that client, and that can have some challenges. Next. So rule 1.4, it talks about the information that you believe that there might be diminished capacity, and if there is a risk of whether it's a physical risk, financial risk, or other type of risk relating to your client, you can take protective action. So when some of the impairment that Joan commented on, if there might be substance use related, if there might be a mental health issue related, if there might be impaired cognitive ability. So this allows the lawyer to take reasonable protective steps to protect that client. And it also says that, next slide, please. So when you are taking those protective steps, this could be maybe that client is at risk for harm. It could be physical harm. It could be financial harm or other type of harm. So rule 1.14 says that when taking that protective action, the lawyer is impliedly authorized to reveal information about that client only to the extent necessary to protect that client's interest. So for example, in my divorce practice, if I found out that my client might be suicidal, or I believe that they are suicidal, I could call the authorities if I felt it rose to that level, and maybe share the client's location, maybe share the client's cell phone information, so that the authorities could ping the client's cell phone and find where that client is. That doesn't mean that I can just share financial information or custody information or the intricacies of that divorce case. So while there is an exception there, it's a very narrow exception focused on what is necessary to protect that client's interest. Next, please. And rule 1.14 regarding communication says that attorneys are supposed to communicate with our clients as though they are a comprehending and reasonable adult. However, that might not be the same if we're dealing with maybe a client that's a child, or they might be dealing with diminished capacity. So this piece, identifying whether there might be any type of impairment, is very important at hopefully during the initial interviews, and identifying these issues as early on in the representation as possible, because that's gonna change how you're communicating with your client throughout the whole case. Next.
Chase, could I make a comment about
Yeah.
that? I think you made a really excellent point about how you don't have to, you can say, this is the thing I'm concerned about, because if you are in fact concerned about a client's well-being and it's serious, the other information isn't going to be something that the mental health crisis responders need to hear, but at the same time, they may need some context. So you might say, I can tell you that the person is going through a contentious divorce, because that may be a context, or it may be that you don't need to say that you just say, I have reason to believe, and I really can't say anymore because of the relationship I have with the person, and that it's a confidential relationship. But right now I am concerned about them, and it's more than what I can do.
Good. And before we move on, regarding communication, you may have clients that if you sent a full set of discovery to it, might be overwhelming to them. You might have to identify how to best communicate with that client. And that might be, well, I'll send them one question at a time, and then you'll get that, because you don't want to overwhelm them. Or maybe they have a condition where you don't call them early on in the morning because they, maybe they take medications in the morning. So the medications are help them maybe better on in the afternoon. Maybe you identify that the best way to communicate with this client is calling them into the office and sitting on the conference room and going question by question and really walking them through them. So it's important not only for making sure that this case operates as smoothly as possible, but so that you're meeting the standards of this rule too.
And I would add to that the client doesn't have to have diminished capacity to need extra support. So the example you gave of not giving them 25 questions for the person who might have an ADHD diagnosis, that's just overwhelming. Even though they can see that they're numbered 1 through 25, they don't know where to start. And you're going to have a much better relationship if you think about, as you would with a client, regardless of whether they have any challenge, what is going to help this relationship to work best.
Moving on to Rule 5.1 and responsibilities of the supervisory attorney. So in firms, I think it's important to think about your office and where you are in kind of the pecking order for responsibilities. And this shows that a lawyer shall be responsible for other violations of another attorney if you are in a partner capacity or managerial capacity, and you have direct supervisory authority over that attorney, and you know that at the time the attorney might be violating the rules, but you fail to take mitigating steps to address those concerns. So this is really important. If you think maybe that associate is drinking a little bit too much, or I'm getting reports that the work isn't rising to the level of competency, but you just kind of ignore it. Maybe you say, well, they're just going through some stuff at home, they'll figure it out. You could be held responsible for that. Joan, do you have any comments on that? I know you really like this rule. It's an important rule.
Well, and it's something where if somebody calls us and they're concerned about one of their lawyers, and they'll start going down the road of, well, I just hope they figure it out, we will say, we suggest you read 5.1, because if it rises to that level, it's going to be a lot more complicated. And that's the thing that will sometimes help people to see that there is some benefit to having that very difficult conversation, because it is a hard one about someone that you are concerned about how they're doing.
Moving along to Rule 2.1, advisor. So representing the client, we all know that that we are supposed to render professional judgment, advice, candid advice to our clients, but only referring to the legal implications might not be enough. We also have to take a look at what moral, economical, social, political factors come into play that might affect our advice with that client. And it takes me back to law school, and mediation class, alternative dispute resolution class, asking the client what it is that they want. So I think sometimes we can get a client in our office and we kind of have our blinders because maybe we've handled a similar case hundreds of times. But really you have to take a look at other factors outside of the letter of the law. And you know, in one example that I a few times I was representing a client, and in that religion, divorce was really frowned upon. So we maybe looked at legal separation or some other avenues to pursue that that could maybe address some of the moral and social factors that were in play there. Next, please. So similarly, purely technical legal advice can sometimes be inadequate. You know, and here's where I think this is really important in an ethical perspective. So although it's proper for a lawyer to refer to relevant moral and ethical considerations in giving advice. And the rule says we're not moral advisors, and while it might conflict with what we advise, it's important that that's a piece. And so we have the ethical rules, we have our own internal moral and ethical views, and then we also have our clients that might have different ethical views or moral views. So it's important to recognize that when you're making a plan, when you're advising your client and you're representing them. Any other thoughts, Joan?
No, I think I'm going to have some thoughts on the next one possibly, but I want to, I'll wait until you have had a chance to weigh in.
Okay. And so this might go beyond the realm of just the facts, applying the facts to the law, because where consultation with the profession in another field is something that a competent lawyer would recommend, you should make that same recommendation. So as a divorce attorney, we regularly would refer to financial experts and run cash flow analyses, or we would get property appraisals done. And that was commonplace. And so this rule applies so that if you're a divorce attorney and another divorce attorney that's competent would make those recommendations, you should too. Similarly, if another competent lawyer is referring an individual to maybe a mental health professional, maybe it's to do a psychosocial eval for whether it's custody or just because you might see some things going on, or maybe you suspect that there are some substance use issues, or maybe the other party is suggesting substance use issues. So it doesn't need to be strictly focused on you know, the financial piece in my divorce situation. It can be really really a lot further than that. Joan?
Yeah, I think that when you look at ethics, it's what can, must, and should you do. So a lot of times we look at ethics rules as this is what I have to do, or this is what I can't do. But I also like to look at what opportunities do the rules give you. So this particular comment to 5.1, to 2.1, and by the way, of course, the rules govern in the comments guide, but think about this. Think about that client who is stressed just because they have the legal problem. Think about the client who feels like you are treating them like an adult, you're having a conversation, you're listening to what they have to say, they rely on you, it helps them so much to talk to you, and they suddenly start really confiding in you. And it can start to feel uncomfortable, and it's sort of a boundary issue. And so that's where this rule can really be a help, because it says that you don't have to be their therapist, that you can say, I think it would be helpful to see a therapist. And the suggestion that, you know, something a competent lawyer would recommend, that's you. And so you can say, I have found that when people are going through the kind of thing you're going through, that it helps move them toward closure more effectively if they're also talking to a therapist. Because here's the part I can do. I'm your lawyer. Remember our retainer agreement? It gave you scope of representation. And some of you may be in a public setting where you're dealing with parties in the public, and it's kind of similar. But to draw that boundary, because otherwise you're going to be in the hole with them with the things that they're dealing with. And not only are you drawing that boundary, but you're also giving permission by saying it's okay. When one professional says, I recommend another professional, it removes some of the stigma around it. And so if your lawyer says people that go through divorces should have a counselor, that makes it much easier than this general idea. Chase, how did you approach that when you were practicing, when you wanted to encourage somebody? What's some of the phrasing that you think would be helpful?
So when I was focused on the case, I would maybe selling that's a little misleading. But if it's going to help in their case, you can say, well, they might raise this issue. Let's address it so that it's done. It's going to help your case to be proactive with the litigation piece. And from on a more personal note, there might be underlying substance use issues or mental health issues. And I would genuinely say, I don't want to see you in this situation again. You know, we can get through this matter, but if the underlying issues aren't resolved, this might end up in another bankruptcy or another criminal charge or another relationship issue. So I think that's where you can really let the clients know that, you know, we all want to do a good job and represent our clients as best as possible. But part of that is we don't want them to continue to have the detrimental consequences that oftentimes result in our representation.
I think you raised something really important, the idea of how it is in the case, because you may have a client who you're pretty sure has an issue and they are saying, no, I do not. And the other side might be saying, this person has an issue. So let's just say it's an alcohol issue and it's a custody case. And your person is saying, no, I do not. And that's what Chase said. Well, let's find out. Let's get it resolved. And so that's where this is really client counseling, where you get to say, well, let's get an evaluation. And if it says there's no issue, we will argue that. And if it says that it is something that is going to be a factor in this case because it is identified, then we will figure out how to deal with it together. And it, you know, because and so that's kind of a nice way. But Chase, how do you say, and I know we're using family law examples here, but you can apply that to whatever area you're in. So let's say that you've got somebody who's, I don't have an alcohol problem, she's nuts, I want full custody. How are you going to tell them? Well, you can see your kids or you can deal with your drinking. What's the way that a lawyer says something like that?
So if there is an issue and we have to plan our defense as well. And I try to identify this as early on in the representation as possible. And even in my initial client packet of information, I say, what can I expect the other party to say about you? Because if alcohol or a mental health issue is present, then I want to get out in front of the case, get that eval done, so that hopefully that if there is an issue, then that gives us time to get to treatment or to at least seek counseling, so that by the time, if it does go to trial, you can say it was an issue, I came to grips with it, I have it resolved, it's not an issue now. Where if there is that defense, say, okay, well, if you don't want to get an eval done, if you don't want to get treatment or counseling done, then that's a factor that could play against you in court. So I want you to be prepared for that, and that decreases, you know, the likelihood that you're going to get the result that you want.
Sometimes you have to be pretty tough. And if they fire you, well, you know, if they're pushing back with you on that kind of a thing because their need to drink or whatever it is more important than whatever result they're claiming they want, maybe that's a client that it's best to have no longer be someone that you're representing.
Because
And that's kind of a harsh thing, but sometimes that's the case. It's okay to fire clients within, you know, what the rules provide. If it's not going to work, because the one that is causing you the most distress has the potential to cause you even more distress, because back where the lawyer is saying, I don't want to deal with this client, I'm not getting back to them, you know, they make a complaint, and then you're really going to have to deal with it.
And some of the challenging piece with that is because there is that stigma, or maybe an attorney is a little bit more uncomfortable asking about a depression issue that they've been dealing with for their whole life versus, you know, what was the value of the property at the time of the marriage. So having these challenging conversations is very critical, especially in practice areas where this happens regularly, and learning more about these issues like you are today will only help.
I'd like to give one more example, and this is a true story. This is a lawyer who came to us and they said, I have a meeting with a client this afternoon. And while I know this isn't a family law program, it is a family law case. And you can look at any individual client that you're representing or working with in any area of law. But this was a family law case. And it was a custody, it included a custody battle. The other side was claiming that the client had mental health issues. The client was insisting they did not. The call to the lawyer came with a request that they needed some help with some life insurance documents. They wanted to make sure they were doing things right. And the lawyer just, you know, their spidey sense was very active. And so the lawyer called and said, you know, my client's been getting more and more distressed, and I don't know, but I'm really kind of worried about them. And I'd like to know some things to say and to do. And Chase will talk about what this means in a little bit, but we transferred them over to our counseling line, you know, explained what we were doing. And they had a conversation about how to ask someone how they are doing if you think that they might possibly be suicidal. And the client came in, and the client wanted to know when the life insurance beneficiary changes were valid, because they wanted to know if they were valid when they mailed it or when they received something back that it was in place. And the lawyer asked some of the questions that they were advised to ask. And what came out was that if they were valid upon mailing, the client had a suicide plan and intended to carry it out. And if they had to wait, well, they would wait. And so the lawyer engaged in a conversation. I mean, it sounds, you know, it's probably pretty intense, but the client agreed that perhaps there were other options and allowed the lawyer to drive them to the ER, where they were identified as having suicidal thoughts with a plan, and they were accepted for whatever treatment followed. So when you think of this, and this is an interesting question to ask in a law school class, because people are talking, you know, it's much more narrower because you don't have the experience yet. But did that lawyer just violate the client's intentions? Did that lawyer, they revealed information? Did that was protected by confidentiality? Did that client have diminished capacity? And all of these questions come up. It's a fabulous law school exam question in a way. And those are the kinds of situations that someone might be faced with. What happened was that the lawyer believes that because the client was willing to say, yes, in fact, I do have some problems and this is what I'm doing about it, that they had a far better result than if they had continued to deny. And For the purposes of this program and others, I asked the then director of the OLPR, and I said, so let's say that somebody does this, and then the client gets angry and said, you did this, and they found out this, and da da da. So you mean if you help to save your client's life, could you get in trouble with us? And of course, the answer was absolutely not. If you did what you thought was the right thing because you thought your client was in danger, that is not going to be an ethical issue. And so as lawyers, that's the kind of opportunity we might have. And the rules are there to, in this case, allow us to do it. And that's where that, you can, you should, and you must comes in. Chase, comments?
Yeah, and I'll get into this in a little bit as we're coming down to our last 10 minutes. But every once in a while, we'll get a call about concerns for a suicidal client. And I want you to know that, well, we likely not be able to provide direct services for that client unless they're a legal professional. We can surely support you and identify options, community resources, and how to talk to them. And similarly, if maybe you have a cousin in Iowa or another friend or family member that might be having these challenges, I want you to know that you can call us and we can talk through those issues with you. So please keep that in mind.
And again, I would repeat that if you have questions or comments, please put those in the chat.
So, and again, the comment to Rule 1.3 regarding diligence says a lawyer's workload must be controlled so that each matter can be handled competently. And this, even though it's a comment, suggests work-life balance. And I want you all to know that this says that it's okay to not take every case. This says that it's okay if you get that one initial consult and maybe it just feels a little off. And if you've been practicing for a while, you've probably learned that lesson a few times. Well, maybe this individual had a couple $1,000s for their retainer, but it just ended up in a tough representation. So I want you all to proactively think about what that looks like, whether you're a solo practice or you're working for a public interest firm or in-house, and take a look at what you can do individually and also what you can do to help support. Maybe you're in a supervisory role and pass that message along to those working under you or supporting those in your office so that they can competently handle each and every matter that they have. Joan, did you want to comment on that or do you want to move on to the, yeah, okay.
Okay, so what do we do with all this? And so there are some things happening in the profession. There's a well-being movement. You've probably heard about it. This is the report that came out in 2017. It's a national task force that wants to create a movement to make change because we have, why are we having these levels of depression and substance use and things like that? And what they made 44 recommendations for 7 groups of stakeholders, and you'll see that does not include individuals, which is why we're talking about these kinds of things in this context, where we're talking about what do we do? And of course, individuals are part of all of these entities. And the 5 core steps they came up with, one of them, is all about the idea that taking care of ourselves so we can do our best work is part of the seminal rule, the 1.1, the first rule, the rule on competence, where if we are not doing what we can do to support providing the kind of legal services that we want to, are we in fact competent? And are we providing competent representation? So it's not anything where you're ever going to get in trouble for not doing well-being. And another thing I'll say about that is you can engage in all the well-being activities that you can find, and you still might get depressed. It's not going to be your fault because you didn't do well-being well enough, but it can help reduce your risk. And there's a lot of resources in our profession. And it does affect our confidence. It does affect our diligence. And so it's critical that we pay attention to that. And I talked earlier about some of the things that give rise to stress for us. I talked about that pessimism, and here it is in this wonderful graphic with the scales of justice. And we'll be sending this over to the law library, so they'll post these slides so you can actually read this. And on one side, we've got that pessimist side, our challenges, the things we look at. And on the other side, we've got what can we do with it. So let's take a look at the one that says 23% elevated stress. That was one of the stats I didn't give earlier, that 23% of us have experienced stress that's at a level that's debilitating. And you think about that, and you think about, or the next one, work addiction, where I've got these 7 things I have to do today. Matters that I have to check off my list or make progress on, okay? And so you're thinking about stuff. But then if you go over to the other side where you're seeing contributing to society, focusing on client care and feeling connected in a sense of belonging. Well, within that stuff, who are the people? And what is the change and what is the opportunity? And so if you think of number 4 on your list and you think about that you have, you are going to have a conversation and you're going to say, I heard back from the other side and they don't agree to what we proposed. Okay, so you now have a client or a party who's distressed. But what if you say, I heard back from the other side. I'm going to tell you what they said. You're probably not going to like it. And then we're going to talk about what we're going to do about it. How different is that? Because you've thought about, how am I going to communicate with that client in a way that helps them, but also helps me to feel, the lawyer as advisor, that I'm making a true difference in how that person is doing today. And it doesn't matter what the area of practice is. If you can see this as my role is as an attorney to be a counselor at law, and it could be to an agency, it could be to an individual, to help them feel that they can move forward or that they're going to be able to deal with a challenge. So I'm going to turn this back over to Chase to talk about some of the resources that are available, a little bit more about LCL services. And as we wrap up here, I would encourage you to put any questions or comments in the chat if you'd like to address them in the last couple of minutes. Chase?
Yeah, thanks, Joan. So here are some links that our website, the path to lawyerable being that maybe you're looking at what you can do in your office, and the path to lawyer well-being will likely have a kind of a roadmap for what you can do to encourage well-being in your office. Lawyer Well-Being Week resources, the Minnesota Supreme Court Well-Being Initiative that started a few years back. And moving on to some of the resources that services that we provide, we can provide up to 4 free counseling sessions per issue, and that's for you or any immediate family members or anybody likely that's at your office. Peer volunteers, we have a network of a lot of members that have experiences, whether in recovery or big firm life or solo practice, and we can make that connection for support. 24-hour hotline, so if you call our office, after hours or on the weekends, you'll be able to talk to a counselor over the phone, and that's free as well. Coaching, and that's what we were talking about. Maybe you have a client that's having some struggles, or a coworker that's having some struggles, or maybe you just see another lawyer or legal professional that's having some trouble. You can call us and we can coach you through how to approach that with them. Referral to community services, treatment center referrals, education like this. So if you're looking to partner up on some type of educational program involving these issues, let us know. Group therapy, we have a list of groups that we provide, anywhere from ADHD group, a well-being group, a weekly AA meeting. Joan facilitates a group for attorneys that are maybe looking to switch areas of practice or trying to figure out what's next in their professional life. I facilitate a group for attorneys that are dealing with ethical issues. It's a safe place to talk about those, whether it's a current complaint or maybe there's a current suspension or or maybe you've been disbarred, or anything else in between. It's a safe place to talk to other attorneys. But most importantly, we're just here to listen to you. So please reach out if we can provide any type of support. We're at 1 o'clock. Here's kind of some directions if you're looking to schedule some sessions with a counselor. That will be provided to the law library as well. And then also, I think that is it. Here's our information. Please keep in mind that Facebook and Twitter are not confidential. LCL is, so if you have some issues, please contact us directly. And we'll wrap it up at that. Thank you for your time. And Joan, do you want to wrap things up?
All right. Thank you so much for joining us today. We really appreciate the opportunity. I'm just going to check the chat here and see, you've got the CLE number. If you want the credit number, it's 474870. It's approved for 1 ethics credit. So delighted to be with you. Contact us if we can help. Thank you so much. Sarah?